Not yet pending.
Yes, but my lord, he had been told, he was aware that the royal family, who are the ultimate adjudicators of who should be king, were intended to appeal. And as I submitted, a very short time thereafter, he launched he made his decision, and that decision is the reason why we're here. One must ask the question, what was so urgent for the president to make that decision? In the face of members of the royal family saying, we want to appeal. The president could have waited and given them the opportunity to have all the matters ventilated and all the various aspects of the identification process ventilated. The last submission, my lord, if your lordship indulges me, is the following. The royal family should not be constricted in what it should consider when they go through an identification process. In other words, they shouldn't be constrained by saying, well, as Justice Madondo says, the will is irrelevant. The royal family, who are the decision makers on the identification process, find it relevant. Justice Madondo can't dictate to the royal family what they should consider in terms of their custom.
It might be here on a more fundamental basis where you and Mr. Fakrin diverge views, where he says, look, it's just an identification of what has been determined by the customs of the Amazulu. And you say, well, there's still a consideration when we get closer to, what did you say in your papers, a constitutional monarchy.
Yes, madam.
So there's some measure of election.
Yes, but my lord, I'm assisted in my thinking by a number of paragraphs in the judgment. So you will see that just to buttress the argument earlier on that says that what was before Madondo was not, or Justice Madondo was not the review. In paragraph 59, somewhere in the judgment, he says, however, it is common cause that this application is not about who the successor to the throne is, but about an interdict against the implementation of the will of the Isilo and the process leading to it. And then somewhere he says, in the premises, the marital status of the applicant and the validity of Isilo will, that's paragraph 59. In the premises, the marital status of the applicant and the validity of the Isilo's will do not in any way stand in the way of the court determining the issue of succession to the Zulu throne. But it certainly stands in the way of the royal family determining the identification of an heir. Because on two theories, the first one is the great wife theory, right? Mm-hmm. If the great wife theory is entrenched in the tradition, it's a status, it's a marital status. How can it be justified that there is a claim that the great wife, I beg your pardon,
wasn't the dispute before Madondo J the proprietary consequences of that marriage?
Sorry?
Wasn't the dispute before Madondo AJP not the proprietary consequences of that marriage?
Yes.
Not the marriage as such?
Yes. No.
Queen Wanfombi's status was never in dispute as the queen,
yes,
or the great wife.
Yes. No.
It was only the proprietary status.
Yes.
Oh, consequences.
Yes.
All right.
But what are the consequences, my lord? If one looks at the consequences of the application, the consequences are that the king's marriages would be regarded as not marriages, the other marriages. So the order that the applicant queen in the Supreme Court of Appeal wishes to have is an order that recognizes that the civil marriage which she entered with the king. And if that is successful, it has implications for the other marriages that were entered into by the king. In other words, we know what those consequences are. Justice Madondo deals with them. But what is critical is that if the applicant queen in the Supreme Court of Appeal succeeds, well, the theory about a great king by birth falls away, because there would be a problem there with the status of the marriage of the king in that instance. So my lord, the argument I really want to press, and your lordship has to engage with this issue. The royal family before you is asking for a procedural right, an opportunity to engage with the identification process. They're saying that process would require us to have the issue of the wills resolved, the issue of the status of the marriage resolved, because it is relevant for them. Forget the logic of it, because that's the royal family saying these are the issues that are relevant for us. What Justice Madondo believes is relevant or not relevant is not what the royal family believes is relevant. The royal family says we want to know what the status of that will is, and I did make submissions on Monday that in the event that the will of His Majesty of the late King, His Majesty King Zwelithini, was lawfully entered into will, then of course the royal family, as Justice Madondo acknowledges, would not likely deviate from what the late King said about in that will. They would not likely deviate. I understand the matters have somehow gone further than they should have. But the point here, my lord, is that the royal family should never be constrained in determining whether or not in the identification process was there a fraud committed on the king's will. They must engage with that. And if they found that there was fraud, they must engage further with what was that fraud intended to do? What was the purpose of that fraud? Who committed it? Why? And my lord, as they engage with those questions, the fog clears, and they can say, when they believe that something was rotten in the state of Denmark, they can now say, no, it's clear, there's nothing that was rotten in the state of Denmark. Everything is clear. But they must be allowed to engage as far as possible with what they consider essentials of the identification process. Now it's clear from our arguments here that the will of a reigning monarch is irrelevant. The will is relevant. What this judgment of Justice Madondo suggests... If
he has identified a successor.
Sorry?
If he has identified a successor, because that is a weighty consideration, that's the relevance.
Yes, if the will names a successor.
Well, in this will, he didn't identify a successor except for the late Queen.
No, he identified a successor.
Except for the late Queen?
Yes. And that is where the theory, my learned friend, Mr. Smilan, will deal with that. But that's where the whole birthright theory falls away. Because if the late king, who was the highest expert in the royal law, did not in his will, assuming the will is valid, did not in his will follow that custom by nominating the child who had been identified as a child born for the purpose of being a king, then we must ask ourselves, does that theory really, is it entrenched in our tradition? Because when the king says in his will, I nominate for a successor, I nominate my wife, Queen Mantombi, I mean Zulu, is he not deviating from this right to birth, right to king by birth practice?
Yes, to that extent he would be deviating from that.
Yes, so that points the direction to which we should go. Because the king can never be suggested that he didn't understand the traditions that govern succession. He understood them very well. And all his sons, all the sons that are eligible for identification, were old enough to be identified or at least to be considered for identification as potential successors. So my lord, So, my lord, the issues, as you would have seen, and my learned friends also acknowledge, the kind of disputes that are raised by this application are such that the res judicata point is just not it has no traction whatsoever. It is being used or activated in an oppressive manner, in a manner that seeks to deprive the royal family of their ancient right, and a right that their grandparents, the great kings of the Zulu nations have followed this pathway. We have to entrench the right of the Zulu royal family to determine and resolve its own affairs. We can't surrender that right to different entities. And the res judicata point would essentially deprive them of that. And we say that, Your Lordship, to the extent you have discretion over that question, you exercise in favor of upholding the rights that the royal family has and determine those questions. My Lord, unless there are any questions, those would be my submissions on the issue of res judicata.
Submissions.
As the court pleases.
Thank you.